Odofo, Chese Yankase Mami, former Chief Justice, Gertrude Torkornoo, Adenji say Yachina na. New petition asanso abone dendenden you see amena okasa no yesi iyokofo ehwehwe action yankse ya maami odofo anyame na make we breaking news abeto dwa fresh meso meje ni nyina brɛ wo Ghanatube yesi Gertrude Torkornoo bana beyi hu ano because another petition kese yede abono no yesi sika twitwiri bie afa ne nsase no nyina no ombra no beyi ne hu ano ya maami yesi ebetwe de sene abasa nde ebetwe de sene abasa ochina echi eka hu odofo yesi ema menda o senia ono so si Ghanafo oma Ghanafo mpanyifo nyina John Dramani maamu oma obi anda no ende no nam court no sin ha no ko international court na ade Ghanafo to say dabi omo betwe de sene abasa pan omema ne ho achi ne pa odofo sisi amena okasa ne maame yehwehwe na achi ne nim ya meso meje ni nyina ebrɛ wo Ghanatube ofuma yenko na yankoje sansemu nyina nchemu nyambra isia wo Ghanatube so.
Right, the wills of the former Chief Justice is not ending anytime soon because the private legal practitioner James Apedo has petitioned the Economic and Organized Crime Office for the arrest and prosecution of the former Chief Justice Gertrude Saki Torkornoo for misuse of public funds and willfully causing financial loss to the state. Now, exactly why are we going on this particular path, and why is he knocking on the doors of Economic and Organized Crime Office, that's EOCO, to look into this matter relating to the former Chief Justice? And here's the reason why. As we do know, it is the Daniel Ofori petition out of the three that the committee that was established to hear the petitions against the Chief Justice established the issue of stated misbehavior. In fact, there were 21 allegations of misbehavior captured in Daniel Ofori's petition and 4 allegations of incompetence. Now, here's what we do know. This is a summary of the number of stated acts of misbehavior, which is one of 3 grounds that the justice or a Chief Justice or a Justice of Superior Court can be removed as enshrined in Article 1461 of the 1992 Constitution. This is it. It counted out 21 of them. The misappropriation of over 337,000 on foreign travels, arbitrarily reassigning cases between judges, dismissed judicial staff over minor offenses, unreasonably fast-tracked Apenyo versus Speaker hearing, ordered national security to seize high court computers, and so many other things that were cited in this said petition by Daniel Ofori, which was the basis on which stated misbehavior was established against the former Chief Justice, and the recommendation by this 5-member committee to have her removed, which has been acted upon by the president. But then again, this private legal practitioner who has petitioned EOCO is coming under the law of causing financial loss to the state. And the petition for the arrest and prosecution of the former Chief Justice, the petitioner is asking EOCO to do a number of things. And his request is based on the following facts. That, and this we're capturing directly from the petition that the petitioner sent to EOCO. We have exclusive copy of this petition by the petitioner to EOCO on the matter of his call for the arrest and prosecution of the former Chief Justice Gertrude Saki Torkornoo. This is exclusive to us here on Ghana Tonight, and this is it. He's basing his demand on the fact that her ladyship, Gertrude Saki Torkornoo, while serving as the Chief Justice and head of the Judicial Service of Ghana, willfully or negligently misapplied public funds when she used funds belonging to the Judicial Service to pay for her husband's travel with her to Tanzania in 2023, as well as paying him per diem for the duration of the private holiday trip, contrary to Section 96, 1, and that's 1C and D of the Public Financial Management Act 2016, Act 921. Also, that Her Ladyship Justice Gertrude Araba Esabasaki Torkornoo, while serving as the Chief Justice and head of the Judicial Service of Ghana, willfully or negligently misapplied public funds when she used funds belonging to the Judicial Service to pay for her daughter's travel with her to the United States of America, as well as paying her per diem for the entire duration of the private holiday trip, contrary to Section 96, 1C and D of the Public Financial Management Act 2016, Act 921. Also, that Her Ladyship Justice Gertrude Araba Sabasaki Torkornoo, while serving as the Chief Justice and head of the Judicial Service of Ghana, willfully caused financial loss to the state when she used funds belonging to the Judicial Service to pay for her husband's travel with her to Tanzania in 2023, plus the said per diem for the entire duration of that particular trip. And in fact, it goes on to ask quite a number of things as well from the IOCO, specific emphasis on the per diems and the trips by the former Chief Justice with her husband and her daughter. That's the basis for this petition for the arrest and prosecution of Gertrude Araba Esaba Torkornoo. That's what the petitioner essentially is asking of the Economic and Organized Crime Office, IOCO. And the petitioner, who has petitioned IOCO to arrest and prosecute the former Chief Justice, is joining us on Zoom right now. He's a private legal practitioner as well, James Alpedo. Counsel, good evening. Thank you for joining us here on Ghana Tonight.
Good evening, Alfred. Thanks for having me.
First off, I mean, when we got this exclusive detail and put it out there, the sentiment is that really, to what end? She's been removed as Chief Justice on the basis of the stated misbehavior, which includes this misappropriation that you reference, that 337,000. And so why are you piling up more trouble for her, going to IOCO to ask IOCO to arrest and prosecute her?
Well, very well. The first issue is that regardless of the outcome of the Constitutional Committee's proceedings, which led to her removal, the committee actually found as a fact that there was misappropriation of public funds or misapplication of public funds. And in the committee's words, from the letter that was sent to her secretly by His Excellency the President through his secretary, and which Her Ladyship decided to send to court, which has now become a public document, the committee stated that her behavior as the head of the judiciary in using those funds to pay for her husband and her daughter's private holiday was unlawful and against any law or policy. And under the Public Financial Management Act, which regulates all public sector institutions, any such conduct as this, which resulted in a loss to the state, is a crime which is punishable under the law separately from whatever has happened leading to her removal from office. So the fact remains that the monies that were spent on those trips were public funds which needs to be recovered for the state. So that is the basis of the petition which I've sent to the IOCO.
The cloud, or you're coming under the power of the law on causing financial loss to the state. Exactly why is that?
Yeah, so if you read those provisions of the law, it gives you the elements that needs to be satisfied before a public officer could be held under those laws. And my argument is that if you look at the findings of the committee, clearly the decision to use those funds for those purposes were willful, and for that matter, the misapplication itself was also willful, and so it fits perfectly under those two provisions of law. That is why I decided to go under those laws for the EOCO to conduct its own investigation. And once they lay hands on the committee's full report, they will get the justification as to why she needs to be brought in for under these two laws, and for that matter, held accountable for it.
I mean, to the extent that this matter, as you referenced, was captured in the petitions that were looked into by the committee. In fact, it is on the basis of one of them, right? This Daniel Ofori petition captured the misappropriation that you talk about, the references that you make, right? It is on the basis of this same Daniel Ofori petition that she was removed. I mean, is this a matter of double jeopardy, you would say?
No, it's not. It's not a matter of double jeopardy. What happened before the committee was essentially an administrative process, a disciplinary process. So what happens is that once the committee found adversely against her that an offense against the Public Financial Management Act has been committed, it means that there must be separate prosecution for those offenses and for her to be held accountable for those as well. Don't forget, she herself has accepted that those findings were correct. That is why in the new application that her ladyship filed in court challenging the president's removal of her as a justice of the Superior Court, she is essentially accepting that the decision to remove her as Chief Justice was correct, as recommended by the committee on those grounds, which also means that once you accept the offense or that you accept the allegation that have been leveled against you as proven, and which then justified your removal as Chief Justice, then it means that the funds that you have misappropriated, which the committee described as unlawful, you would have to be held accountable for that by a court of competent jurisdiction. It is only at that point that she can make a claim. It is only after that if any subsequent prosecution comes up, that she can make a claim about double jeopardy. But for now, that claim cannot hold water.
I see. So the end objective of you asking EOCO to step into this matter is not for her to refund the money. You want her arrested and made to face the full rigors of the law, prosecuted for that matter.
In fact, we are asking for both, because the whole purpose is for the money that has been spent, if that money has not already been refunded to the state, to be refunded. But it does not also mean that the crime has not been committed. So she can be held separately for that as well. So my petition is basically asking for the Economic and Organized Crimes Commission to office to take the first step of looking into this petition, procuring a copy of the committee's report, and once the EOCO comes to the decision that indeed the offense under the Public Financial Management Act has been committed, and also the Criminal Offences Act has been committed, then to proceed under the fiat of the Attorney General to haul her before court for the crime. If after that EOCO decides to recover the money, that is even better for us, because we want accountability, and that is what this is all about.
I see. Stay with me a bit, Mr. Pedro. And I also have another private legal practitioner, that's Christian Mamhesi, joining us as well. Counsel, good evening. Thank you for joining us. And you heard the petitioner. It's also
Order for when you're breaking news about to judges, see I am a man who I share. See I know the I am a me a baby dignity aqua because just a petition upon petition yet bono. den pa adagye kra ene ho petitions upon petitions ene ye de boy maami we ende ye de we abon ochna ye de we abon ya sake no o se da bi onte ase o se ku case ni ga court ena yesanso de new petition asan be bon biom se onko iyoko nonko yi ne ho ano because sikatwitwi die bi afa ne nsase tama na o acting anasi yedini si akonya so as Chief Justice of the Republic of Ghana for we ene ensem ayi dejanti si an yesi yen yehwehwe na achi ne dendenden a ensem na ayi dejami so bigini nyina bro e wo Ghanatube for mamro fi se mobile like no ma subscribe no ma share no ma hit notification bell so ma send be a abrini abibia drop content say ya wo una me no kasa no we dan tempa no ahwe no wetem for aha ena me de ye ma me get to Torkornoo nsem nyina besi e wo Ghanatube so makra mu nyina beda mu nyina celebrate